Case 1, Kimberly Fry, August 2009, Washington County Superior Court, North Kingstown, Rhode Island. There are moments in a community's history that leave a permanent mark. Moments that force neighbors, investigators, and entire systems to pause and ask how something so devastating could have unfolded behind closed doors, in a quiet home, in a town where most people would say nothing like this ever happens. North Kingstown, Rhode Island, is one of those communities. And the name Kimberly Fry is one of those permanent marks. Kimberly Fry was a mother. She was married. She lived in a residential neighborhood in North Kingstown, a coastal community in Washington County in southern Rhode Island. From the outside, her life had structure. There was a home. There was a family. There was a daughter. Her daughter's name was Camden Fry. Camden was 8 years old. She was a child who, like all children her age, had difficult moments. The kind of moments that are part of growing up, the kind of moments that parents navigate every single day. On the evening of August 2009, Camden was having one of those moments. According to court records and testimony presented at trial, Camden refused to take a bath and became upset. What followed was described in court as a prolonged period of frustration that lasted approximately 2 hours. What happened next is at the center of one of the most heartbreaking criminal cases in Washington County's modern history. According to testimony and evidence presented by prosecutors during the trial, Kimberly Fry strangled her 8-year-old daughter that evening. Camden Fry did not survive. When investigators and emergency responders arrived at the family home, Camden was found unresponsive. She was pronounced dead. The medical examination that followed confirmed the cause of her passing, and the investigation that immediately opened would eventually bring Kimberly Fry before a jury of her peers in Washington County Superior Court. But to understand the full weight of this case, it is important to understand what investigators and prosecutors uncovered in the weeks and months before the tragedy, because what emerged painted a picture of a household under severe emotional strain, with warning signs that had been visible to professionals long before that August night. Court records reveal that less than 2 weeks before Camden's passing, Kimberly Fry had attended a session with a family therapist. During that session, according to testimony presented at trial, Fry made deeply alarming statements. She told the therapist that she blamed her 8-year-old daughter for her own depression. She described herself as an incompetent mother. She said the situation felt hopeless. Those are not the words of a parent navigating ordinary parenting stress. Those are the words of a parent in a serious mental health crisis, a crisis that, according to the therapist's own account, was alarming enough to warrant immediate action. The therapist, according to court records, directed Fry's husband to monitor her closely and to take her to the emergency room if her condition deteriorated. That instruction was issued less than 2 weeks before Camden Fry lost her life. On the night Camden passed away, investigators discovered that Kimberly Fry had also consumed a combination of prescription medications, painkillers, antidepressants, and sleeping pills, in what prosecutors described as a failed attempt to take her own life. A 5-page letter addressed to her husband was recovered from the home. In that letter, according to court records, Fry wrote that she could not take it anymore and described herself as worthless as a mother and as a person. The letter was entered into evidence and became a central document in the prosecution's case. While Fry was hospitalized in the aftermath of that evening, she made statements to hospital staff that were later presented in court. According to testimony, she told one hospital employee that she had strangled her daughter and that she wanted to die. She told another staff member that Camden had been crying and that she had simply wanted it to stop. Those statements, combined with the physical evidence and the testimony of the family therapist, formed the backbone of the prosecution's case when the matter came before Washington County Superior Court. Kimberly Fry stood trial and faced a jury of her peers. Her defense raised the issue of her mental health, arguing that the events of that evening needed to be understood in the context of a mother who was in the grip of a severe psychological crisis. The defense pointed to the documented history of mental health struggles, the sessions with the therapist, and the medication Fry had taken that same night as evidence that this was not a premeditated act, but rather the devastating outcome of an untreated and unmanaged mental health emergency. The prosecution, however, argued that the evidence demonstrated a knowing and intentional act. Prosecutors pointed to the 5-page letter, to the statements made to hospital staff, and to the warning signs that had been identified by a professional just days before Camden's passing. They argued that regardless of Fry's mental state, her actions that evening had taken the life of an 8-year-old child who had no ability to protect herself. After deliberating, the jury returned a verdict of guilty on the charge of second-degree murder in 2011. The verdict meant that the jury found Kimberly Fry responsible for the death of her daughter Camden under Rhode Island law, while stopping short of the first-degree murder charge that would have required a finding of premeditation. At sentencing, Washington County Superior Court handed down a sentence of 40 years, with 20 years to serve at the women's prison at the Adult Correctional Institutions in Cranston, Rhode Island. The remaining 20 years were suspended. Fry was also placed on probation for 27 years upon release. Fry did not serve the full 20 years. According to public records, she was released from the Adult Correctional Institutions on Christmas Eve after accumulating sufficient good behavior credits to reduce her sentence by more than 10 years. Her release was met with reaction from members of the community who had followed the case and who continued to hold Camden's memory in their thoughts. Fry's case did not end with her release. She subsequently pursued a legal appeal, with her attorneys arguing that her mental health condition at the time of the offense should have been given greater weight in the proceedings. The appeal brought renewed attention to the case and to the broader conversation about how the criminal justice system addresses defendants with documented mental health histories. But at the center of every legal argument, every appeal filing, and every court proceeding, there remained one unchanging fact. An 8-year-old girl named Camden Fry lost her life in her own home. A child who had every right to grow up, to laugh, to struggle with baths and tantrums, and all the ordinary challenges of being 8 years old. A child who deserved protection above all else. Camden's case became a reference point in Rhode Island for conversations about the intersection of mental health, parenting, and the systems that are supposed to intervene before tragedy occurs. The fact that a therapist had issued a warning less than 2 weeks before Camden passed away, and that warning had not translated into the intervention Camden needed, was a question that lingered long after the verdict. Child welfare advocates in Rhode Island pointed to the Fry case as evidence that when mental health professionals identify a parent in crisis, the pathways for protecting children in that household must be faster, clearer, and more responsive. The gap between a therapist's warning and a child's safety should never be measured in days. Camden Fry was 8 years old. She deserved every year that followed. The justice delivered through Washington County Superior Court was the only justice the system could offer, and it could never be enough. If you or someone you know is experiencing a mental health crisis or concerns about child safety, the Child Help National Child Abuse Hotline is available 24 hours a day, 7 days a week, at 1-800-422-4453. Trained counselors are ready to help. If this case moved you the way it moved so many in Rhode Island, please take a moment to like this video, leave a comment below, and subscribe to Cold Case Hour. Your support allows us to continue bringing these stories forward, because every victim deserves to be remembered, and every story deserves to be told. Case 2, Michele Rothgeb, 2014, Providence County Superior Court, Providence, Rhode Island. There are cases that shake a state's child welfare system to its foundation. Cases that force legislators, social workers, and the public to confront the uncomfortable truth that the systems designed to protect the most vulnerable children are sometimes failing them in plain sight. The case of Michele Rothgeb and her 9-year-old daughter Ginalys is one of those cases. It is a case that did not just end in a courtroom. It reverberated through every office of the Rhode Island Department of Children, Youth and Families, and prompted a reckoning that is still discussed by child welfare professionals in the state today. Michele Rothgeb lived in Providence, Rhode Island. She was the mother of Ginalys Rothgeb, a 9-year-old girl whose short life was marked by conditions that investigators, prosecutors, and child welfare advocates would later describe in terms that capture the weight of profound institutional failure alongside individual responsibility. The circumstances that brought this case before Providence County Superior Court began when emergency responders were called to the Rothgeb home after Ginalys was found unresponsive. The 9-year-old was discovered in a bathtub, a discovery that triggered an immediate investigation by law enforcement and child welfare authorities. What investigators found when they entered that home went beyond the immediate tragedy of Ginalys' condition. According to court records and investigative reports, the conditions inside the Rothgeb residence were consistent with extreme and prolonged neglect. The environment in which Jeanne had been living was documented as unsafe and deeply unsanitary. Investigators described conditions that indicated that the home had not been maintained as a safe living environment for a child for a significant period of time. Jeanne Rothgeb did not survive. The 9-year-old child passed away, and the medical examination that followed contributed to the foundation of a criminal case against her mother, Michele Rothgeb. Prosecutors in Providence County moved forward with a charge of manslaughter against Michele Rothgeb. The charge of manslaughter under Rhode Island law reflects a finding that a person's conduct, whether through action or through a failure to act, caused the death of another person in circumstances that, while not constituting premeditated or deliberate conduct, demonstrate a level of recklessness or negligence that the law holds criminally accountable. In Jeanne's case, the charge of manslaughter was rooted in what investigators and prosecutors described as a sustained failure to provide the child with the care, supervision, and safe environment that every child is entitled to receive. The conditions documented at the Rothgeb home were not the result of a single bad day or a momentary lapse. They reflected a pattern that had existed long enough to leave visible and documentable evidence throughout the household. What made the Rothgeb case particularly significant in Rhode Island, beyond the loss of a 9-year-old child, was what the investigation revealed about the contact the family had previously had with the Rhode Island Department of Children, Youth and Families, commonly known as DCYF. Reports indicated that there had been prior involvement with the child welfare system in connection with the Rothgeb household. That involvement, and the question of whether the system had done everything within its power to protect Jeanne before the tragedy occurred, became a central point of public and legislative scrutiny in the aftermath of her passing. Rhode Island lawmakers and child welfare advocates demanded answers. How had a 9-year-old child been living in conditions described as extreme neglect without the intervention necessary to remove her to safety? What had the state's child welfare system known, and when had it known it? Were there case workers who had visited the home? Were there reports that had been filed and not acted upon with sufficient urgency? Were there systemic failures, understaffing, inadequate training, or overwhelmed caseloads that had contributed to Jeanne remaining in that home? These questions did not have simple answers. But the fact that they were being asked, loudly, publicly, and with legislative force, was itself a direct consequence of Jeanne Rothgeb's passing. A 9-year-old child's death had forced Rhode Island to look directly at the gaps in its child protection system. Providence County Superior Court proceedings against Michele Rothgeb moved forward on the manslaughter charge. The case presented prosecutors with the challenge of establishing criminal responsibility in circumstances involving neglect, an area of criminal law that requires demonstrating not just that a parent failed to act, but that the failure rose to a level of recklessness or gross negligence that caused the child's death. The evidence gathered by investigators, the documented conditions of the home, the physical state in which Jeanne had been found, and the medical findings from the examination following her passing, provided the foundation for the prosecution's case. The picture that emerged in court was of a child who had been failed by the person most responsible for her welfare. Jeanne Rothgeb was 9 years old. She was a child who went to sleep and woke up in a home that investigators described as unfit for a child to live in. She was a child who deserved clean surroundings, nutritious food, supervision, warmth, and safety. She deserved to be protected. She deserved to grow up. The Rothgeb case became a landmark moment in Rhode Island's ongoing struggle to improve its child welfare infrastructure. Legislative hearings were convened. Reviews of DCYF protocols were ordered. Advocates pushed for increased resources for frontline child welfare workers and for clearer guidelines on when children must be removed from unsafe environments, regardless of the administrative burden such removals create. None of those reforms could bring Jeanne back. But the only hope that emerges from tragedies like hers, is that the systems that failed her will be strengthened enough to protect the next child, and the child after that, and every child whose name might otherwise appear in a future investigation. Jeanne Rothgeb deserved better. The justice pursued in Providence County Superior Court was the justice the system could offer, and Rhode Island's child welfare community carries the weight of her name as a reminder of what is at stake when a system falters. If you want to make a difference for children in Rhode Island and across the country, the Child Help National Child Abuse Hotline is available at 1-800-422-4453, 24 hours a day, 7 days a week. Trained crisis counselors are ready to help. Please like this video, leave a comment, and subscribe to Cold Case Hour. Every case we cover is a child who deserved better, and every subscriber helps us make sure their stories are never forgotten. Case 3, Kaitlyn Nolan, August 2023, Kent County Superior Court, Warwick, Rhode Island. Warwick, Rhode Island, is a city of neighborhoods, a community of families, of children playing in yards, of summers spent near the water. It is not the kind of place where people expect to encounter the kind of story that unfolded in August of 2023. But on a summer day in that year, a tragedy occurred that would lead investigators not only to the scene of a drowning, but into a household that they later described in court filings and public records in terms that captured a level of neglect that shocked even experienced law enforcement officers. Kaitlyn Nolan was a mother living in Warwick, Rhode Island. She had a 3-year-old son named David Holloway III, known to those who loved him as DJ. On a day in August of 2023, DJ was not where he should have been. He was not inside the family home under supervision. He was not in a fenced yard with an adult nearby. He was in a neighbor's swimming pool, unsupervised, unattended, and in danger. By the time DJ was found in that pool, it was too late. The 3-year-old did not survive. Emergency responders were called. Investigators arrived. And what began as a response to a child drowning quickly expanded into a far broader investigation, one that extended from the neighbor's pool directly into the home where DJ had been living. When law enforcement entered the Nolan residence, what they documented there became central to the criminal case that followed. According to police body camera footage and investigative reports subsequently reviewed by prosecutors and presented in court proceedings, the conditions inside the home were described as deplorable and deeply unsafe for children. Officers documented the presence of extensive trash throughout the home. They found evidence of insect infestation, including maggots and fleas. The living environment captured on body camera footage was one that prosecutors would later describe as wholly inconsistent with a safe environment for any child, let alone a 3-year-old. But the conditions inside the living areas of the home were not the only thing that alarmed investigators. In the basement of the residence, law enforcement documented the presence of approximately 40 marijuana plants. The cultivation of that many plants in a basement shared with a family home where young children were present added a significant dimension to the investigation and contributed to the charges that followed. Kaitlyn Nolan was arraigned in November of 2023 in Kent County Superior Court on 5 counts of cruelty to or neglect of a child. The charges reflected prosecutors' assessment that DJ's drowning and the conditions documented in the family home were not the result of a single momentary lapse, but rather evidence of a sustained failure to provide a safe and supervised environment for the children in that household. The father of DJ, David Holloway II, was also charged in connection with the case and similarly arraigned in Kent County Superior Court. Both Nolan and Holloway pleaded not guilty to the charges against them. As of the latter part of 2024, the case remained active in Kent County Superior Court, with legal proceedings ongoing. The drowning of DJ Holloway in August of 2023 prompted immediate conversations in Warwick and across Rhode Island about the supervision of young children around water, particularly private swimming pools in residential neighborhoods. 3-year-old children have virtually no capacity to protect themselves in aquatic environments. Their survival depends entirely on the vigilance of the adults responsible for them. The presence of a pool, whether belonging to a neighbor or to the family itself, requires a level of supervision that cannot be interrupted or delegated. But DJ's case was not simply about a momentary loss of supervision at a pool. The conditions documented inside the Nolan residence told a story of a household environment that had deteriorated over time, an environment in which the baseline safety and welfare needs of the children living there had not been consistently met. The body camera footage reviewed by investigators and referenced in court filings painted a picture that extended well beyond the single tragic afternoon of DJ's drowning. DJ Holloway was 3 years old. He had his whole life ahead of him. Years of growth, of learning, of the ordinary and extraordinary experiences of childhood. He deserved a safe home. He deserved supervision. He deserved to be protected by the adults responsible for him. That protection was not provided, and the courts of Kent County, Rhode Island, were called upon to pursue accountability on his behalf. Child safety advocates in Rhode Island pointed to DJ's case as a reminder that the safety of very young children depends entirely on the environments their caregivers create and maintain. A safe home is not merely a preference, it is a fundamental right of every child. When that right is denied, the consequences can be irreversible. DJ Holloway deserved better. Kent County Superior Court continues to pursue justice in his name. Please like this video, leave a comment below, and subscribe to Cold Case Hour. DJ was 3 years old, and his story deserves to be heard. Case 4, Jessaline Andrade, 2021, Providence County Superior Court, Pawtucket, Rhode Island. Pawtucket, Rhode Island, is one of the state's oldest cities, a community with deep industrial roots and tightly woven residential neighborhoods. It is a city where families live in close proximity to one another, where neighbors know neighbors, and where the sounds of children playing are a familiar part of daily life. In 2021, Pawtucket became the center of a case that brought investigators, prosecutors, and child welfare advocates face to face with one of the most devastating consequences of the opioid and fentanyl crisis that has affected communities across Rhode Island and the entire United States. Jessaline Andrade was a mother living in Pawtucket. She had a 2-year-old son. In 2021, that 2-year-old child passed away. The medical examination that followed his passing produced findings that became the foundation of a criminal case that would be brought before Providence County Superior Court. The medical examiner's findings in the case of Jessaline Andrade's son determined that the 2-year-old child had died as a result of acute fentanyl intoxication. That finding, a toddler, 2 years old, losing his life due to exposure to fentanyl, placed this case at the intersection of the state's child protection system, its criminal justice apparatus, and the devastating public health emergency that fentanyl has created in communities across America. Fentanyl is a synthetic opioid of extraordinary potency. It is many times more powerful than morphine and a significant number of times more powerful than heroin. In adults, even a small quantity can be lethal. In a 2-year-old child, whose body weight is a fraction of an adult's and whose developing systems have no tolerance whatsoever for such a substance, exposure to fentanyl carries catastrophic risk. The fact that a 2-year-old child could be exposed to fentanyl at a level sufficient to cause his passing speaks directly to the environment in which he was living and the circumstances his caregivers had allowed to develop in that home. Investigators who examined the circumstances surrounding the child's passing built a case that led to criminal charges being filed against Jessaline Andrade in 2021. The charges brought before Providence County Superior Court reflected the prosecution's determination that the child's exposure to fentanyl was the result of a failure, a profound, preventable, and ultimately fatal failure, on the part of the adult responsible for his care. The case of Jessaline Andrade's son became part of a broader and deeply troubling pattern that Rhode Island prosecutors, law enforcement officials, and public health authorities had been documenting for several years. The proliferation of fentanyl in the state's communities had created environments in which children were being exposed,
in some cases with fatal consequences, to substances that had no place anywhere near a child. The accessibility of fentanyl in residential settings, combined with the incapacitating effects of addiction on parental judgment and caregiving capacity, had created conditions in which young children were at risk in their own homes. Rhode Island's response to the opioid and fentanyl crisis had involved significant investment in treatment, recovery, and harm reduction services. But the criminal cases that emerged from homes where children had been harmed or had lost their lives due to fentanyl exposure forced a parallel conversation, one that centered not on the adults struggling with addiction, but on the children living in the households where addiction had taken hold. Child welfare advocates in Rhode Island pointed to cases like that of Jessaline Andrade's son as evidence of the urgent need to strengthen the intersection between addiction intervention services and child protection protocols. When a parent is in the grip of a substance use disorder, the children in that household are not passive bystanders. They are residents of an environment that the addiction has made dangerous. Their safety requires proactive intervention that connects parents with treatment, while simultaneously ensuring that children are living in conditions that meet their fundamental welfare needs. 2 years old. That is how old Jessaline Andrade's son was when he passed away. He had not yet reached the age where he could communicate clearly, protect himself, or understand the danger he was in. He was entirely dependent on the adults around him. He deserved a childhood. He deserved protection. He deserved to grow up. The proceedings in Providence County Superior Court were Rhode Island's attempt to deliver accountability for a 2-year-old child who could no longer speak for himself. The investigation, the charges, and the legal process that followed were conducted in his name. Because every child who loses their life in preventable circumstances deserves the full weight of the justice system on their behalf. If you or someone you know is struggling with substance use, or if you have concerns about a child's safety, please reach out. The Child Help National Child Abuse Hotline is available at 1-800-422-4453, 24 hours a day, 7 days a week. Please like this video, share it with someone who needs to hear it, and subscribe to Cold Case Hour. These children deserve a voice, and you help us provide it.
Case 5, Tiffany Vanstone. August 2024, Providence County Superior Court, Johnston, Rhode Island. Johnston, Rhode Island, is a residential community situated in the heart of Providence County, a town of neighborhoods, of families, and of the kind of quiet suburban life that most residents associate with safety and stability. In August of 2024, however, a situation unfolded in Johnston that brought law enforcement, child welfare authorities, and ultimately criminal prosecutors into a home where 5 children had been living in conditions that investigators, court records, and town officials would describe as wholly unacceptable for human habitation, let alone for the habitation of children. Tiffany Vanstone was a mother of 5 children. The youngest of those children was 7 weeks old at the time law enforcement entered the family home in August of 2024. When officers arrived at the Vanstone residence, what they documented there formed the basis of a criminal case that would result in Vanstone's arrest on 5 felony counts of child cruelty and neglect. According to investigative reports, law enforcement documentation, and statements from town officials in the aftermath of the case, the conditions inside the Vanstone home at the time of the police response were described as uninhabitable. Officers documented the presence of extensive accumulations of household waste throughout the residence. They found evidence of food that had been left to spoil, with moldy food items documented in areas of the home. The overall state of the residence was sufficiently alarming that town officials subsequently condemned the property, a formal legal declaration that the structure was no longer safe for occupancy. 5 children had been living in those conditions. 5 children, ranging in age from 7 weeks to older siblings, had been residing in an environment that the town of Johnston's own officials determined was unfit for anyone to live in. The youngest of those children, the 7-week-old infant, had been in that environment since birth. The Rhode Island Department of Children, Youth and Families was notified immediately upon law enforcement's response to the Vanstone home. All 5 children were removed from the residence and placed in the care of DCYF. The removal of 5 children from a household, including an infant just 7 weeks old, was a step that child welfare authorities take only when the evidence of risk to the children's welfare meets the threshold required under Rhode Island law. In the case of the Vanstone children, the documented conditions of the home met and exceeded that threshold. Tiffany Vanstone was arrested and charged with 5 felony counts of child cruelty and neglect, 1 count corresponding to each of the 5 children found in the home. The felony nature of the charges reflected the seriousness with which Providence County prosecutors viewed the conditions in which those children had been living. A felony charge of child cruelty and neglect in Rhode Island carries significantly greater legal consequences than a misdemeanor charge and signals a prosecutorial determination that the conduct in question was not a minor or momentary failure, but a sustained and serious breach of the duty of care owed to a child. The Vanstone case drew attention in Johnston and across Rhode Island for several reasons. The presence of an infant just 7 weeks old among the children found in the condemned home was perhaps the most striking element. A 7-week-old child is among the most vulnerable human beings on Earth. A newborn at that age cannot regulate their own temperature, cannot communicate distress, cannot move away from danger, and cannot survive without constant and attentive care. The idea of a 7-week-old infant living in the conditions documented by investigators at the Vanstone residence prompted immediate and strong reactions from the community, from child welfare advocates, and from members of the public who followed the case through local media coverage. The broader context of the Vanstone case also included a conversation about the speed and effectiveness of child welfare monitoring in Rhode Island. 5 children in a household, with a newborn infant, in conditions that ultimately led to the condemnation of the property. The question of whether any earlier intervention could have prevented the children from being exposed to those conditions for as long as they were became a subject of discussion among those who work in and advocate for Rhode Island's child protection system. Child welfare professionals consistently note that cases involving neglect, as opposed to more visible forms of harm, are among the most challenging to identify and act upon. Neglect often develops gradually, over time, in households that may have had prior contact with child welfare services for other reasons or no prior contact at all. It is a form of harm that does not always present with the immediate visibility of other types of abuse, but its consequences for children's physical health, developmental progress, and emotional well-being can be just as severe. The 5 children removed from the Vanstone home in August of 2024 were placed into the care of DCYF and, through the child welfare system, into environments where their immediate needs could be addressed. The 7-week-old infant and each of the older children were given access to the medical attention, nutrition, and safe surroundings that every child is entitled to from the moment of their birth. Tiffany Vanstone faced the full weight of Providence County's criminal justice system in connection with what was documented in her home. The 5 felony counts she faced reflected the reality that when 5 children are found living in condemned conditions, the law in Rhode Island treats that as a serious criminal matter, because it is. Every child in that home deserved better. Every one of them deserved a clean and safe environment. Every one of them deserved to grow up in a home where their physical and emotional needs were the first priority of the adults responsible for them. Johnston's community, Providence County prosecutors, and Rhode Island's child welfare system responded to the Vanstone case with the urgency it required. The children were protected. The legal process moved forward, and the accountability that those 5 children deserved was pursued in their names. Please do not forget to like this video, leave your thoughts in the comments below, and subscribe to Cold Case Hour. Every child in this story had a name and a future, and every one of them deserved better. Case 6, Elaine Yates, arrested 2017, original offense 1985, Providence County Superior Court, Rhode Island. Some cases in the American criminal justice system span decades. Some offenses do not come to light for years, or in some instances, for more than 30 years. The case of Elaine Yates is one of those cases. It is a story that begins in 1985 in Rhode Island, disappears for more than 3 decades, and resurfaces in 2017, when a woman who had been living under an assumed name for the better part of her adult life was finally located and brought before Providence County Superior Court to face accountability for what she had done. Elaine Yates was a mother. In 1985, she was involved in a custody dispute, a legal proceeding in which the courts of Rhode Island were in the process of determining the appropriate custody arrangement for her 2 daughters. Custody disputes, even contentious ones, are a recognized and regulated part of the family law system. Rhode Island's family courts exist precisely to navigate these situations, to hear from both parties, to consider the welfare of the children involved, and to arrive at an arrangement that serves those children's best interests. Elaine Yates did not wait for the court's determination. In 1985, according to court records and the investigation that was eventually reopened decades later, Yates took her 2 daughters and left. She did not comply with the custody proceedings. She did not inform the court of her whereabouts. She did not allow the children's father or the Rhode Island family court system to maintain any contact with the girls. Instead, she disappeared, and she took her daughters with her. What followed was a fugitive existence that lasted for more than 30 years. Elaine Yates lived under an alias. She built a life in which her true identity was concealed. Her daughters grew up without the presence or knowledge of their father. The Rhode Island court order that had been issued in connection with the custody dispute, an order that Yates had chosen to defy, remained outstanding for decades while investigators and family members attempted to locate them. The act of abducting one's own children during a custody dispute is a criminal offense in Rhode Island and across the United States. Parental abduction, the act of taking a child in violation of a custody order or in a manner intended to prevent the other parent or the court from exercising legal authority over custody arrangements, is treated seriously by the legal system because it inflicts profound harm on multiple parties simultaneously. The children involved are denied the right to a relationship with the other parent. The left-behind parent is subjected to years or decades of anguish, uncertainty, and loss. And the courts, whose authority exists to protect children, are undermined. In the case of Elaine Yates, her two daughters spent more than 30 years separated from their father and from the Rhode Island family and legal systems that should have had oversight of their upbringing. Whatever life Yates built under her assumed name, it was a life constructed on the foundation of a criminal act committed against her children's father and in defiance of the judicial system. In 2017, that foundation finally gave way. Investigators located Elaine Yates after more than 30 years. She was arrested and brought before Providence County Superior Court to face charges related to the 1985 abduction of her daughters. The arrest, more than 3 decades after the original offense, demonstrated something important about the Rhode Island justice system and about law enforcement's commitment to pursuing accountability regardless of how much time has passed. The case of Elaine Yates prompted significant public interest when the arrest was made in 2017, not only because of the extraordinary length of time that had elapsed since the original offense, but because of the questions it raised about the experiences of the two daughters at the center of the case. Those daughters had been young children in 1985. By 2017, they were adults, women who had grown up in the shadow of a decision their mother had made before they were old enough to understand it or consent to it. The human dimensions of a parental abduction case that spans more than 30 years are extraordinarily complex. The daughters in question had lived lives, had formed identities, relationships, and experiences during those decades. The legal proceedings of 2017 brought all of those complexities into the public record and into the consideration of Providence County Superior Court. Parental abduction is sometimes discussed as a less serious category of offense than other crimes against children because, the reasoning goes, the children are with a parent who presumably loves them. But that framing misses several critical realities. Children who are abducted by a parent in defiance of a court order are denied the right to know and be known by their other parent. They are raised in secrecy, often under false identities, in circumstances that require concealment and deception as a condition of daily life. They are denied access to the protections of the judicial system that was supposed to safeguard their welfare. And they are denied the ability to make an informed choice about the circumstances of their own upbringing. Elaine Yates made a choice in 1985 that affected the lives of her two daughters for more than 30 years. The criminal justice system of Rhode Island, through Providence County Superior Court, ultimately responded to that choice, decades later, but with the full weight of accountability that the law provides. The case stands as a testament to the persistence of the justice system and as a reminder that the passage of time does not erase the consequences of the choices adults make at the expense of their children. Please like this video and subscribe to Cold Case Hour. If this case made you think, leave a comment. We read every single one. Case 7, Maria Asciolla, June 2022, Newport County Superior Court, Jamestown, Rhode Island. Jamestown, Rhode Island, is a small island community in Narragansett Bay, a place of historic character and close-knit residential life. It is the kind of community where people tend to know one another, where trust runs deep between neighbors and families, and where the idea that a child could be subjected to harm within a circle of people who were supposed to protect them is especially difficult to absorb. In June of 2022, Newport County Superior Court delivered a sentence in a case involving a Jamestown woman, Maria Asciolla, that brought the community face to face with exactly that kind of harm. Maria Asciolla was a woman living in Jamestown, Rhode Island. Between 2016 and 2018, a period of approximately 2 years, prosecutors established that Asciolla had sexually assaulted a male relative who was under the age of 14 at a location in Jamestown. The victim was a child. The perpetrator was an adult. The relationship between them was one of family, a relationship that, by its very nature, should have been a source of safety, trust, and protection for the child. The investigation that ultimately led to charges against Maria Asciolla involved the gathering of evidence across multiple fronts. Cases involving the sexual abuse of a child by a family member are among the most difficult that investigators and prosecutors encounter, not because the law is unclear, but because the circumstances in which such abuse occurs are typically characterized by secrecy, by the manipulation of the child's trust, and by the exploitation of the inherent power imbalance between an adult and a young relative. Children in these situations are often reluctant to disclose what has happened to them because the perpetrator is someone they know, someone who is part of their family structure, and someone whose actions they may not fully understand or be able to articulate. Prosecutors in Newport County built a case that covered the 2-year period from 2016 to 2018 and established through evidence and testimony that the abuse had occurred at a location in Jamestown on multiple occasions during that period. The victim was a male child under the age of 14 throughout the period in question. Maria Asciolla was charged with 4 counts of first-degree child molestation. Under Rhode Island law, first-degree child molestation is among the most serious charges that can be brought in connection with offenses against children. It carries mandatory minimum sentencing requirements and reflects the legislature's determination that the sexual abuse of a child by an adult constitutes one of the gravest categories of criminal conduct. Asciolla pleaded to the charges against her. In June of 2022, Newport County Superior Court sentenced her to serve 3 years in prison. The sentence was the court's formal response to 4 counts of first-degree child molestation, to 2 years of abuse that had been perpetrated against a child within a family setting, in a community where the child should have been safe. The sentencing of Maria Asciolla was covered by Rhode Island media and drew attention from child safety advocates who noted the significance of the charges and the conviction. Cases in which an adult family member is held criminally accountable for the sexual abuse of a child are vital, not only because they deliver justice for the individual victim, but because they send a clear message that family relationships do not provide cover for criminal conduct. There is no category of relationship, not a family bond, not a position of authority, not a history of trust, that renders an adult immune from criminal accountability for the abuse of a child in their care or in their family circle. For the victim in the Asciolla case, the male relative who had been subjected to abuse between 2016 and 2018, the criminal proceedings represented a measure of official acknowledgement and accountability. The Rhode Island justice system recognized what had happened to him, pursued charges on his behalf, and delivered a verdict and sentence that affirmed the seriousness of what he had endured. Child advocates consistently note that the majority of child sexual abuse is perpetrated not by strangers, but by individuals known to the child, family members, family friends, and others who have established a position of trust and proximity. That reality makes the work of identification, investigation, and prosecution more complex, but it also makes it more urgent. The criminal justice system's willingness to pursue these cases, regardless of the family relationships involved, is one of the most important tools available for the protection of children. Maria Asciolla was sentenced to 3 years in prison by Newport County Superior Court in June of 2022. The child she had abused between 2016 and 2018 deserved that accountability. He deserved to have the system stand on his side. Please like this video, leave a comment below, and subscribe to Cold Case Hour. Every child abuse survivor deserves to know that their story matters, and that the people who harmed them are held accountable. Case 8, Ginalys Velasquez Camara, 2019, Providence County Superior Court, Providence, Rhode Island. Providence, Rhode Island, is the state's capital, its largest city, its center of commerce and culture, and the home of a diverse and complex community that encompasses every facet of Rhode Island life. It is a city of neighborhoods, of immigrant communities, of families building lives in an urban environment that is simultaneously intimate and sprawling. In 2019, Providence became the site of a criminal case involving a newborn child, a case that raised urgent and painful questions about the circumstances in which a new life can be lost before it has barely begun, and about the responsibilities that the law places on those who bring a child into the world. Ginalys Velasquez Camara was a woman living in Providence. In 2019, she gave birth to a son. That newborn child was subsequently found without life in a Providence apartment. The circumstances surrounding the infant's passing prompted an immediate investigation by Providence law enforcement and child welfare authorities, an investigation that would eventually lead to criminal charges against Velasquez Camara before Providence County Superior Court. The initial charge brought against Ginalys Velasquez Camara was murder. As the investigation developed, and as prosecutors examined the full evidentiary record of the case, that charge was subsequently altered to involuntary manslaughter through the indictment process. The shift from murder to involuntary manslaughter reflected prosecutors and the grand jury's assessment of the specific circumstances surrounding the infant's passing, circumstances that centered on a failure to provide the newborn with necessary medical care following his birth. A newborn child's survival in the first hours and days of life depends entirely on medical attention. Newborns require immediate assessment of their vital signs. They require warmth, nutrition, and monitoring of their breathing. They require the attention of medical professionals who can identify and respond to the range of complications that can arise in the immediate post-birth period. When a newborn does not receive that care, when the adults present at or following the birth fail to seek the medical assistance that a new child's life requires, the consequences can be fatal. In the case of Ginalys Velasquez Camara's son, investigators determined that the newborn had not received the medical care his condition required following his birth. The infant passed away. The medical findings from the examination of the child contributed to the development of the criminal case against Velasquez Camara. Providence County Superior Court proceedings in the Velasquez Camara case took place against a backdrop of broader conversations in Rhode Island and nationally about the circumstances in which newborns can be abandoned or fail to receive care following unassisted or unsupported births. Rhode Island, like many states, has enacted safe haven legislation, laws that provide a legal, non-criminal pathway for parents who feel unable to care for a newborn to surrender that child safely, without fear of prosecution, at a designated location such as a hospital, fire station, or police station. The existence of safe haven laws reflects a societal recognition that there are situations in which a parent may feel desperate, overwhelmed, or without support, and that providing a safe, legal option for surrender is preferable to the alternative of a newborn being abandoned or left without care. The case of Ginalys Velasquez Camara's son did not involve the use of Rhode Island's safe haven provisions. It involved a newborn child who was found without life in a Providence apartment, a child who, investigators determined, had not received the medical attention his survival required. The indictment for involuntary manslaughter brought Velasquez Camara before Providence County Superior Court on the charge that her failure to seek necessary medical care for her newborn son had resulted in his passing. Involuntary manslaughter under Rhode Island law encompasses situations in which a person's conduct, whether through action or through the failure to take a necessary action, causes the death of another in circumstances that, while not deliberate, demonstrate a reckless disregard for human life or a gross failure to fulfill a duty of care. In the case of a newborn child, the duty of care owed by the parent is absolute and immediate. That duty begins the moment a child enters the world. It does not wait. It does not allow for delay. And when that duty is not fulfilled, when a newborn is left without medical attention in circumstances where that attention is necessary for survival, the law holds the person responsible for that failure accountable. The loss of a newborn child under any circumstances carries a weight that is almost impossible to fully articulate. A new life, just arrived in the world, full of every possibility that a human life contains, and gone before it has had any chance to unfold. Providence County Superior Court's pursuit of accountability in this case was its response to that loss. It was the justice system's way of saying, on behalf of a child who never had the chance to say it himself, that his life mattered, that his arrival in this world mattered, and that the circumstances in which he was lost were not acceptable. Rhode Island's safe haven law remains available for any parent who finds themselves in a crisis following the birth of a child. Any hospital, police station, or fire station in Rhode Island will accept a newborn, no questions asked, under the provisions of that law. No child needs to be lost when that pathway exists. Please like this video, subscribe to Cold Case Hour, and share this story. Awareness saves lives, and every subscriber helps us keep telling the stories that need to be told.
Case 9. Lorrie Carter. August 2024. Providence County Superior Court, Lincoln, Rhode Island. The summer months in Rhode Island bring heat. They bring the particular intensity of New England summers, days that climb into the upper 80s and beyond, where the air holds warmth long after the sun has reached its peak, and where the interior of an enclosed vehicle can reach temperatures that climb far above the outside air within minutes of the engine being switched off. It is in this context, the context of a Rhode Island summer, of a parking lot, of a vehicle sitting in the August heat, that the events surrounding Lorrie Carter and a 7-month-old infant unfolded in August of 2024. Lorrie Carter was 55 years old and a resident of Foster, Rhode Island. On a day in August of 2024, Carter arrived at the Lincoln Mall, a shopping complex in Lincoln, Rhode Island, in Providence County. She had with her a 7-month-old infant. What happened next, specifically, the decision that Carter made upon arriving at the mall, became the center of a criminal investigation and the basis for her arrest and subsequent charges. According to law enforcement records and investigative reports, Carter left the 7-month-old infant alone and unattended inside a parked vehicle in the mall parking lot while she went inside the shopping complex. The vehicle's engine was not running. The infant was left in conditions that, as the summer heat acted upon the enclosed space of the vehicle, became dangerous. Law enforcement was alerted to the situation, and officers responded to the parking lot. When they located the vehicle containing the 7-month-old infant, what they found prompted immediate action. According to the investigative record, the interior temperature of the vehicle had reached a level that placed the infant at serious risk. The infant was observed to appear flushed and to be perspiring, physical signs consistent with the body's response to heat exposure that, in a 7-month-old child, represent a medical concern requiring immediate attention. Officers made the decision to break a window to gain access to the vehicle and to reach the infant. The infant was removed from the vehicle and assessed. Emergency response procedures were initiated to address the child's condition following the period of exposure to the heat inside the enclosed vehicle. When Lorrie Carter was located and spoken to by law enforcement, she provided an account of her actions to investigators. According to the investigative record, Carter stated that she had been away from the vehicle for approximately 20 minutes, time during which she was described as getting food and shopping inside the mall. She told officers that her usual practice was to leave the vehicle's engine running when she left a child inside, but that on this occasion she had been unable to locate her spare key, and had instead left a window cracked open before going inside. That account of the practice of leaving an engine running, of a window left cracked as an alternative, was part of the evidentiary record reviewed by investigators, and subsequently considered in connection with the charges brought against Carter. A 7-month-old infant cannot open a car door. A 7-month-old cannot roll down a window. A 7-month-old cannot call for help, cannot move to a cooler area, and cannot regulate their own body temperature in the way that an older child or an adult can. An infant of that age in a vehicle with a cracked window on an August day in Rhode Island is entirely at the mercy of the conditions around them, and the conditions created by summer heat in an enclosed vehicle can become life-threatening with extraordinary speed. Lorrie Carter was arrested following the incident and charged with cruelty to or neglect of a child under Rhode Island law. The Department of Children, Youth and Families was notified of the incident and involved in the response to ensure the welfare of the infant. The charge brought against Carter reflected Rhode Island law's treatment of the act of leaving a young child unattended in a vehicle under conditions that pose a risk to the child's welfare. Rhode Island, like many states, has addressed the specific issue of children left in vehicles through child protection statutes that hold adults criminally accountable when their decisions to leave a child unattended expose that child to foreseeable harm. The infant in Carter's case survived the incident. Law enforcement's timely response and the decision to break the vehicle's window to reach the child meant that the outcome of this case was not the same as cases in which children left in hot vehicles do not survive. But the survival of the infant does not diminish the seriousness of what occurred or the legal accountability that Rhode Island law attaches to the decision to leave a 7-month-old child alone in a vehicle on an August afternoon. Child safety experts and public health authorities consistently emphasize a simple principle in connection with vehicle safety and young children. There is no duration of time that is safe for leaving an infant or young child alone in a vehicle with the engine off, regardless of weather conditions, regardless of how briefly the adult intends to be gone, and regardless of whether a window is left open. The speed at which vehicle interior temperatures can rise to dangerous levels, particularly in summer months, is such that a matter of minutes can be sufficient to place a child's life at risk. Lorrie Carter's arrest and charges in August of 2024 were Providence County's response to a decision that placed a 7-month-old infant at serious risk. The infant was safe, the legal process moved forward, and the principle that young children cannot be left unattended in situations that expose them to foreseeable harm was affirmed through the criminal justice system. Please like this video and subscribe to Cold Case Hour. Your support means the world, and every comment lets us know these stories are reaching the people who need to hear them. Case 10, Latifat Kotun, September 2019, Providence County Superior Court, Providence, Rhode Island. Providence, Rhode Island, September of 2019. A 3-year-old child is brought to Hasbro Children's Hospital, the state's primary pediatric hospital and one of New England's leading centers for children's health care. The child is 3 years old. She is brought in with injuries, and those injuries, reviewed by the medical staff of one of Rhode Island's most experienced pediatric institutions, are assessed as severe. What happened next set in motion a chain of events that would bring Latifat Kotun, a 21-year-old mother from Providence, before Providence County Superior Court on 3 counts of first-degree child abuse. Latifat Kotun was 21 years old in September of 2019. She was the mother of the 3-year-old girl who was admitted to Hasbro Children's Hospital during that month. When medical staff at the hospital examined the child, what they found was, according to the hospital's reporting and the subsequent investigation, consistent with physical maltreatment. The injuries sustained by the 3-year-old were described in the investigative and prosecutorial record as severe, a characterization that reflected the medical team's assessment of the nature and extent of what the child had experienced. Hasbro Children's Hospital's medical staff are trained to recognize the difference between accidental childhood injuries and injuries that are consistent with deliberate physical harm. That distinction, the medical determination of whether a child's injuries are consistent with maltreatment, is one of the most critical tools available to the child protection system. When medical professionals identify injuries in a child that are inconsistent with accidental causes, their reporting obligation triggers an investigation that can mean the difference between a child remaining in danger and a child being placed in safety. In the case of Latifat Kotun's 3-year-old daughter, the hospital's assessment led to a report to the Rhode Island Department of Children, Youth, and Families. DCYF opened an investigation. Law enforcement became involved, and the evidence gathered through that investigation formed the foundation of the criminal charges that were subsequently brought against Kotun in Providence County Superior Court. Kotun was charged with 3 counts of first-degree child abuse. Under Rhode Island law, first-degree child abuse encompasses the infliction of serious physical harm upon a child, and carries significant criminal penalties reflecting the gravity with which the state treats the physical maltreatment of a minor. 3 counts, reflecting the severity and multiplicity of what investigators and prosecutors determined had been done to this 3-year-old girl. Following the investigation, Providence County prosecutors secured a court order requiring Kotun to have no contact with her daughter. The child, who had been brought to Hasbro Children's Hospital with severe injuries, was not returned to Kotun's care. She was protected through the judicial and child welfare systems of Rhode Island. The case also resulted in a second child being removed from Kotun's custody by the state. The involvement of a second child, and DCYF's determination that this child also needed to be placed in protective custody, indicated that investigators and child welfare authorities' concerns extended beyond the 3-year-old who had been admitted to Hasbro Children's Hospital. The removal of both children from Kotun's custody was the state's most immediate and concrete act of protection on behalf of 2 children who had been living in a home where, according to prosecutors, the risk of harm was real and documented. The case of Latifat Kotun moved through Providence County Superior Court with the weight of the evidence gathered by investigators, the medical findings of Hasbro Children's Hospital, and the involvement of DCYF on behalf of the 2 children at its center. A 21-year-old mother, charges of first-degree child abuse, and a 3-year-old girl whose injuries had been severe enough to require hospitalization at Rhode Island's premier pediatric medical facility. For the 3-year-old at the center of this case, and for the second child who was also removed from the household, the involvement of the justice system and of DCYF represented the intervention they needed. The medical professionals who identified the injuries, the investigators who built the case, the prosecutors who filed the charges, and the child welfare workers who removed both children from the household and placed them in protective care. All of these individuals and institutions played a role in ensuring that the harm these children had experienced was acknowledged, that accountability was pursued, and that those children were placed in environments where they could begin to be safe. 3 years old. That is how old Latifat Kotun's daughter was when she was brought to Hasbro Children's Hospital with injuries that shocked medical staff. 3 years old. Old enough to have her own personality, her own laughter, her own way of experiencing the world. And young enough to be entirely dependent on the adults around her for her safety. She deserved that safety. Every child does. Providence County Superior Court's pursuit of accountability in the Kotun case was justice delivered on behalf of a 3-year-old who could not pursue it herself. The Rhode Island child welfare and justice systems, working together, as they must, ensured that she was heard. This documentary has examined 10 cases from across the state of Rhode Island, 10 women, 10 criminal cases, and in every single one of them, at least one child, and in several cases multiple children, who deserve to be safe, to be cared for, and to grow up protected. The cases of Kimberly Fry, Janae Rothgeb, DJ Holloway, and every other child named in this documentary are reminders of what is at stake when adults fail in their responsibility to the children in their care. They are reminders of why child welfare systems exist, why criminal statutes protecting children must be enforced, and why the community's willingness to pay attention, to report concerns, and to speak up on behalf of children who cannot speak for themselves is one of the most important things any of us can do. If you have concerns about a child's welfare, please contact the Child Help National Child Abuse Hotline at 1-800-422-4453. It is available 24 hours a day, 7 days a week. You can also contact the Rhode Island Department of Children, Youth and Families directly. A call can change a child's life, and in some cases, it can save one. Thank you for watching Cold Case Hour. If this documentary moved you, please like this video, leave a comment below sharing your thoughts, and subscribe to Cold Case Hour so you never miss another story. Every subscription helps us continue this work, because every victim deserves a voice.